It's been a chaotic few weeks in the ongoing legal war between Blake Lively and Justin Baldoni, and just when many believed one side had fumbled the ball, a closer look at the court record tells a very different story. What looked like a missed deadline and a quiet collapse of a multi-million-dollar defamation case was, in reality, a calculated legal move, one that may reshape the trajectory of this entire dispute. And to understand where we are now, we have to rewind to the moment that decision was made. For days, observers were waiting for Baldoni and his production company to file an amended complaint in their massive defamation countersuit. Headlines began circulating suggesting they had failed to meet a deadline. Major outlets quickly framed it as a win for Lively. The narrative took hold almost instantly. Baldoni had missed his opportunity and the case was effectively dead. But that interpretation left out a crucial detail. Baldoni's attorney, Brian Friedman, publicly clarified that no deadline had been missed at all. According to Friedman, the decision not to amend the complaint was intentional. The strategy was to preserve appeal rights. That distinction matters more than most people realized at the time. Back in June, U.S. District Court Judge Louis J. Lyman dismissed Baldoni's $400 million defamation countersuit against Lively, her husband Ryan Reynolds, and their publicist, as well as Baldoni's separate $250 million defamation lawsuit against the New York Times. However, the dismissal did not automatically end every possible legal avenue. Baldoni's team had been given the opportunity to amend specific claims, including breach of implied covenant and tortious interference. Choosing not to amend meant accepting dismissal at the trial level, but keeping the door open for appeal. If they had amended and failed again, the ability to challenge the ruling at a higher level would likely have been foreclosed. That is the part many headlines glossed over. The legal strategy was not about conceding defeat, it was about shifting battlegrounds. By October 31st, after Baldoni's team declined to file a further amended complaint, Judge Lyman entered final judgment. Notably, Lively responded to the court requesting that the judgment be declared final and that her request for legal fees remain active, a request the judge granted. Around that same time, Lively addressed the situation publicly, speaking about the emotional toll of retaliatory litigation and expressing support for others who may not have the resources to fight back. Her statement framed the dismissal as a broader victory against what she characterized as weaponized legal action. But behind the public messaging, the legal chessboard was still very much in play. The decision not to amend signaled something larger. Baldoni's team was preparing to escalate. And now, with the appeal process unfolding, the implications extend beyond just two celebrities locked in a high-profile dispute. One of the central arguments emerging from Baldoni's side is that proceeding aggressively at the state level while the federal appeal is pending would create unnecessary duplication, wasted resources, and potentially conflicting rulings. The contention is straightforward. If the federal dismissal is overturned, it could materially impact the posture of related proceedings. If different courts reach inconsistent conclusions about the underlying legal merit of the claims, the entire matter could spiral into procedural chaos. From their perspective, pausing certain actions until the federal appellate court weighs in is not delay for delay's sake, it's a matter of judicial efficiency. And the financial stakes are enormous. Between Baldoni, Lively, their respective legal teams, related parties, and the involvement of a major media institution like the New York Times, the litigation has already consumed substantial resources. This is not symbolic litigation. The dollar figures, $400 million and $250 million, reflect how high each side believes the reputational damage to be. At the heart of the case against the New York Times is the allegation that the publication rushed its reporting and relied on improperly obtained information, publishing a damaging article with insufficient time for meaningful response. Baldoni's team argues that the reporting went beyond aggressive journalism and crossed into defamation. The Times, for its part, has defended its reporting as protected speech grounded in legitimate news-gathering practices. That tension between press freedom and reputational harm is one reason this appeal carries implications far beyond the individuals involved. Judge Lyman's dismissal was not framed as a declaration that the claims were baseless in an absolute sense. Rather, the ruling centered on whether the pleadings, as structured, met the required legal standards. That nuance is critical. A dismissal for insufficient pleading is not the same as a factual determination that allegations lack merit, and that is precisely the space Baldoni's team appears to be targeting in the appellate process. As it stands, this case is no longer just about personal grievances or public perception. It has evolved into a test of how far defamation law can stretch when powerful public figures and major media institutions collide. The appeal could clarify the boundaries of media liability, the scope of anti-SLAPP protections, and the threshold plaintiffs must meet when alleging coordinated reputational harm. For now, the strategy shift is clear. What appeared to be a missed move was in fact a repositioning, and whether that gamble pays off will depend on how the appellate court interprets the legal framework surrounding this high-stakes confrontation. As the appeal process moves forward, the broader legal strategy becomes easier to see. By preserving their right to challenge Judge Louis J. Lyman's dismissal at the appellate level, Justin Baldoni and his legal team are effectively asking a higher court to re-examine whether the claims were dismissed too narrowly or too early. Appeals are not about retrying facts, they focus on legal interpretation. That means the battleground now centers on whether the trial court correctly applied defamation standards, anti-SLAPP protections, and pleading requirements when it threw out the $400 million countersuit and the separate $250 million action against the New York Times. From Baldoni's perspective, the appeal is about correcting what they view as a legal misstep. If the appellate court finds that certain claims were improperly dismissed, the case could be revived and sent back down for further proceedings. That possibility alone significantly changes the leverage dynamic between the parties. In high-stakes civil litigation, procedural positioning can be just as powerful as factual evidence. The decision not to amend the complaint now looks less like retreat and more like consolidation before advancing on a different front. Meanwhile, Blake Lively's legal posture remains firm. Following the dismissal, she publicly framed the outcome as vindication. In her statement, she spoke about the emotional toll of retaliatory litigation and described the experience as painful but ultimately empowering. The court's agreement to keep her request for legal fees active also signals that her team intends to pursue reimbursement for at least part of the substantial costs incurred defending against Baldoni's claims. Legal fees in complex federal cases can quickly escalate into the millions, especially when multiple defendants and media entities are involved. Ryan Reynolds, though not the primary focus of the dispute, was also named in the countersuit and therefore stood to benefit directly from the dismissal. While he has largely remained quiet publicly, his inclusion underscored how wide Baldoni's allegations were cast. It wasn't simply a dispute between two individuals, it was framed as a coordinated effort involving spouses, publicists, and media outlets. The involvement of the New York Times elevates the case to another level entirely. Defamation claims against a major publication are notoriously difficult to win in the United States because of the actual malice standard established in Supreme Court precedent. Public figures must prove not only that statements were false and damaging, but that they were published with knowledge of falsity or reckless disregard for the truth. Baldoni's team argues that the reporting process fell short, particularly in how information was gathered and how much opportunity he was given to respond before publication. The Times maintains that its reporting met journalistic standards and falls squarely within First Amendment protections. If the appellate court sides with Baldoni, even partially, the ripple effects could be significant. Media organizations would be watching closely, as a revived claim could signal a willingness by courts to scrutinize newsroom practices more aggressively at the pleading stage. On the other hand, if the dismissal is upheld, it reinforces the high bar plaintiffs must meet when challenging major publications. At the same time, related proceedings at the state level remain intertwined with what happens federally. Baldoni's team has argued that pushing forward on certain state matters before the federal appeal is resolved risks duplicative litigation and conflicting conclusions. Their position essentially asks the courts to pause and allow the appellate review to clarify the landscape before further resources are expended. Given the extraordinary sums already spent, the argument for efficiency carries practical weight. What makes this case particularly complex is the blend of celebrity, corporate media, and modern public relations warfare. Public statements, social media posts, legal filings, and media coverage have all fed into one another in real time. At various points, narratives have shifted based on incomplete information or procedural misunderstandings. The initial wave of headlines suggesting Baldoni had simply missed a deadline is a clear example of how quickly perception can harden before the full legal context is understood. Now, the case sits in a transitional phase. The federal appeal represents the next critical checkpoint. It will determine whether Baldoni's claims are permanently extinguished or given new life. For Lively, a confirmed dismissal would solidify her legal victory and potentially clear the path for recovery of fees. For Baldoni, success on appeal could reopen litigation on a scale that few celebrity disputes ever reach. And as the courts weigh these questions, the larger issue remains unresolved. Where exactly is the line between aggressive investigative journalism and actionable defamation when powerful public figures are involved? The answer may not come quickly, but the appellate decision will move the needle in one direction or the other. What happens next will likely define not only the future of this dispute, but the broader conversation around celebrity litigation and media accountability. If the appellate court upholds Judge Louis J. Lyman's dismissal in full, Justin Baldoni's $400 million countersuit and his $250 million action against the New York Times will effectively remain closed chapters in federal court. That outcome would reinforce just how difficult it is for public figures to overcome anti-SLAPP protections and the constitutional safeguards surrounding press freedom. It would also strengthen Blake Lively's legal position considerably, particularly if her request for attorney's fees moves forward without obstruction. On the other hand, if even a portion of the dismissal is reversed, the case could return to the trial court with renewed force. Discovery could reopen, internal communications could be examined, editorial processes might be scrutinized, and the narrative would shift once again, from whether Baldoni's claims were procedurally sufficient to whether they can survive factual examination. That distinction is critical. A reinstated claim does not guarantee victory, but it does guarantee leverage, and in litigation of this magnitude, leverage shapes negotiations, strategy, and public messaging. The financial dimension cannot be overstated. Between Baldoni, Blake Lively, Ryan Reynolds, their legal teams, and the New York Times, this battle has already consumed extraordinary resources. These are not symbolic lawsuits filed for headlines. They are deeply contested claims involving reputational stakes that reach into careers, business ventures, and long-term public perception. Every procedural motion, every filing, every appeal carries strategic consequences, measured not only in dollars but in credibility. At the center of it all is a larger legal tension. Defamation law in the United States was intentionally structured to protect robust journalism, especially when reporting on public figures. Yet the same framework leaves room for litigation when reporting crosses into alleged falsehood or reckless disregard. Baldoni's appeal tests whether the trial court applied that balance correctly. The New York Times' defense tests the durability of First Amendment protections in an era when high-profile disputes unfold under intense public scrutiny. Meanwhile, Blake Lively's public posture has noticeably shifted compared to earlier stages of the controversy. After her statement following the dismissal, she has maintained a lower profile regarding the litigation. That restraint may be strategic. In cases like this, public commentary can become evidence. Silence, in contrast, can project confidence. Whether intentional or advised, the change reflects a more measured phase of the dispute. As the appellate court reviews the legal arguments, the case remains suspended between two potential futures. In one, the dismissal stands, and the federal chapter closes with finality. In the other, the lawsuit is revived, and the conflict escalates into a prolonged evidentiary battle that could redefine how celebrity defamation cases are litigated against major media institutions. For now, the appeal is the pivot point. It represents Baldoni's calculated gamble that the initial dismissal did not fully account for the strength of his allegations. It represents Lively's opportunity to cement what she views as a decisive legal victory. And for the New York Times, it is a defense not just of a single article, but of newsroom practices that underpin investigative reporting nationwide. When the appellate decision arrives, it won't simply determine who advances and who retreats. It will clarify the legal boundaries that govern how reputations, reporting, and retaliation intersect in the modern media era. And in a case this visible, that clarification will resonate far beyond the parties whose names appear on the docket.